As the Chief Investigator of the Major Safety Investigation Unit, I don't normally get applause when I make an entrance, but thank you. And thanks very much for giving me the opportunity to speak about what is, as I perceive it, a fairly topical subject for the members or the people in this room. The feedback I'm getting from industry is that we're facing challenges with managing, first of all, psychosocial hazards and risks, and we're also needing to step up in the way that we are to investigate them, to identify remedial measures and ways that we can do things a little bit better. So I'm going to keep my presentation fairly practical and pragmatic today. So the starting point is, well, what I want to talk about is what, first of all, the regulators' expectations are, and I'll then move on to more about what we see as the common deficiencies in investigating this subject matter, and come up with some solutions, hopefully, that you can apply in your business to address those gaps, if you like, or safeguard against some of the risks that we have with investigations, so we can get the most out of our internal investigations into this subject matter. So just to touch firstly on the legislative context, I think many in this room would probably consider that we're dealing with a relatively novel hazard in terms of psychosocial hazards, and in particular what I'm talking about is harmful behaviours. And maybe that perception is grounded in the fact that of recent times we've had really specific and prescriptive work health and safety regs come into play, and also a code of practice as well. The reality is that, you know, when you look at the definition of what health means under the 2011 Work Health and Safety Act, it includes both physical and psychological health. So the reality is managing these sorts of hazards in the workplace is not new. We might have that perception, and we haven't had the focus perhaps that we should have until recent times, but the reality is it's been made very clear that we've had general duties to manage this sort of hazard at least 2011, if not back to the 2000 Act and also the 83 Act, where there's been general duties to manage occupational health, safety and welfare back in those days. But it's been made crystal clear to us. The regulations have been amended, and they talk about treating harmful behaviours, which I'm focusing on, but more broadly psychosocial hazards, by adopting a risk management approach. So identifying them as hazard firstly, assessing them, and then controlling them. And in particular, the regs point us to those regulations in the Work Health and Safety Regulation, the general regulation about risk management, which is talking about things like our hierarchy of control and applying that to these hazards. And, you know, Professor Hopkins talked about major hazards and catastrophic hazards. If anyone's experienced an issue with psychosocial hazards in the workplace, absolutely destructive. I've experienced a number of occasions where I've gone into businesses after, in particular, where harmful behaviours have been raised, and it tears workplaces apart. And in many cases, it can result in really serious and long-term psychological harm. You know, the regulator's just commenced its first prosecution, or two prosecutions in fact. You might know we've gone back from the District Court to the Industrial Court. This is the first matter in the Industrial Court, and the allegations is that there was a failure to manage psychosocial hazards, not in this case harmful behaviours, but it was things like unjust procedural fairness, poor support through managers and supervisors, and debilitating work practices that had the effect of rendering fatigued workers being subjected to these hazards. So, you know, it's something that we need to be conscious of, and it's something that we need to be on the front foot first of all to manage, and then from my perspective talking to you today, if we're not getting it right, properly investigating them and taking them seriously. You'll see that the code of practice is probably the most helpful for those in the room. Very practical guidance in terms of, in particular, controls, and you'll see how broadly the definition of harmful behaviours is. It's something that, to be quite honest, over the last 10 or 15 years, when we've been looking more and more at bullying and harassment type complaints, those sort of factors that are forming the definition now of harmful behaviours were being characterised as part of the bullying and harassment complaints. So the regulator's at least been investigating them for 10 or 15 years. And that coincides with the guidance material around bullying and harassment. So what we're seeing now is, just like we did 10 or 15 years ago, where the number of complaints regarding bullying and harassment significantly increased in accordance with some of the literature and the authoritative guidance, we're now starting to see psychosocial hazards being reported more and more, coinciding, of course, with the regulations and the code of practice as well. So in terms of the regulator's expectation, what the regulator is expecting in terms of psychosocial hazards generally, but in this case harmful behaviours, is clear reporting, issue resolution and investigation procedures being in place that are not only in place but are actually in practice implemented, and they extend to harmful behaviours. We don't necessarily expect a perfect investigation, but what we would like to see is the conduct of an investigation into these sorts of matters that may be imperfect but timely, independent, objective, transparent, fair and unbiased. And, you know, like all your investigations, should be deep and detailed. But I guess the major takeaway for today for the people in this room is that the investigations need to be approached through a risk management lens. So it's not, you know, harmful behaviours, psychosocial hazards are not human resource or industrial relations matter. The legislation, the regs, the codes of practice make clear that they are safety risks and they need to be treated that way. So the investigations can't just be focused upon the events, if you like, that give rise to the complaints, but they also need to be focused on the risk management aspects that you probably apply to your, if I can call them, general safety related investigations. So have we identified the hazard? What do we have in place to do that? What have we done to assess it? You know, for example, we talked about, Professor Hopkins talked about bow ties. Has there been a bow tie in your organisation around psychosocial hazards? The regulator's just recently gone through its own bow ties, and one of those, and one of the more recent ones was the psychosocial hazard bow tie. And then how we're controlling it. So we need to be benchmarking how we're controlling these risks against the codes of practice and the authoritative guidance that's available to us. Do people have the right training to support them? When you think about it, where the rubber hits the road with managing most of these sorts of harmful behaviours is really at the workface. You know, and so, you know, our supervisors and our line managers, who are probably very good technically insofar as mining is concerned, now have to be at least competent enough to identify, firstly, the potential of or the existence of harmful behaviours, and then to address it. And so that's a challenge for those sorts of people, and we've got to be able to be, as a business, be supporting them to identify, to help them understand what they need to be looking out for and how they need to address these sorts of behaviours. We will, and these matters that I've raised here in terms of our expectations, these are the sorts of things that the regulator considers when we're triaging complaints that are made to us. So we'll look at those sorts of things to determine what our response might be and how, on what level will that response be. And the first thing we typically do, if we're satisfied the complaint has some justification, is that we'll issue a Section 155 notice for the mine's investigation report. And we'll do a desktop review. That investigation report may be subject of privilege or it may not. If it's subject of privilege, we would say to you, we'd ask you to consider waiving that privilege so we can have a look at it, because we might be satisfied when we have a look at your investigation and your report that there's nothing for us to do further. And you may legitimately say, well, we've got a legal right of privilege over that report and the investigation, and we're not providing it to you. And we'll say, okay, well, we probably don't have any other choice but to now enter your workplace and start investigating. And so we know and we're sensitive to the fact of how disruptive an investigation can be when our guys go in and compel people to answer questions and compel documentation and speak to 10 or 20 people, particularly in these sorts of investigations, throughout the workforce. So we're sensitive to the impact that that can have, and if it's not necessary for us to do that and the matter can be better resolved in another way, then I think that's in everybody's interest, including the complainants in these matters. So we will typically firstly ask the question, when we get a complaint, has the complaint been raised with the mine? And if it hasn't been, unless it's a really serious matter, but generally speaking, we will put it back on the mine or make sure that it's raised with the mine so it can be dealt with in accordance with your issue resolution procedures, which the legislation contemplates. If it has been raised with the mine and not investigated, we're likely to go in and investigate it. If it has been raised with the mine and it's been investigated adequately, and it's not a really serious risk, like it's not an extreme risk, and in particular, when I talk about compelling production of reports, if those reports reveal to us that you've identified failings and you've taken post-incident remedial action, that might be changing of systems and providing other controls. It might also be taking performance management action against individual perpetrators involved. If we look at that and we're satisfied that that's an appropriate outcome, then that could very well be the end of the matter. There may be, as there was in the case that we're now prosecuting, where the mine did do the right thing. They did an external investigation. It was an adequate investigation. Remedial measures were implemented. Individuals were held accountable for their actions. However, in this particular case, the risk was so serious to the extent that the two workers involved haven't returned to work for a couple of years now, that we couldn't ignore it despite all those sorts of factors. So there's a range of things. We don't investigate every, if you want to talk about physical safety related matter, we take a risk-based approach, and we do so in respect of these matters as well. And there's some of the factors that we have a look at. So, just question and ask yourselves, are we okay in that regard? Have we got those sorts of processes in place? And is that how we're managing our harmful behaviours if one happens to be reported internally to us? More significantly, I want to talk really about the common deficiencies and the safeguards that you can put in play to manage those deficiencies in your investigation. And this is based on 25 odd years of me investigating these matters. It's based upon me calling upon my team and their experience about what they've seen as the common deficiencies. So it's a fairly well-informed, I think, identification of what the issues are and how you can go about addressing them. bearing in mind that it's the major investigation unit that will typically be the ones that will investigate these sorts of matters because of the speciality that's required in terms of investigating psychosocial hazards and risks, as well as which include harmful behaviours. So first of all, one of the deficiencies is the perception, not the reality, but the perception of impartiality or a conflict of interest, usually on the part of the complainant. It's something that can be very dangerous because if you don't manage it well, it doesn't matter what you do in terms of your investigation and the outcomes, that the matter will not finalise unless the complainant is satisfied and others involved are satisfied that the matter's been dealt with fairly, which includes impartially and without a conflict of interest. So think about independency in terms of your investigation. Okay, now that's, removing the investigation's not connected to any of the parties involved in the incident. Now that might mean, and you can bet your life in many of your investigations into these sorts of matters, even though HR, industrial relations, persons might be responsible for the investigation, the perception of many complainants will be, well, they're just part of the management of the organisation. So, a good investment can be engaging an external firm, whether they're lawyers and so on. And that's there are other considerations here, but one of the considerations might be to be thinking about, do we need to manage this potential perception that will not let this matter go away, no matter what we do, and can we do that by engaging externals or an independent? Make sure your investigation findings are evidence-based and not speculative, okay? So when you're sitting down and explaining to a complainant or an alleged perpetrator what the outcomes are, you're relying upon evidence. You're not relying upon speculative subjective opinions, and you're able to identify how these reasonings came about to your findings. And make sure your process and the outcome is transparent. I've gone into businesses previously in my former life as a consultant where I've been engaged by companies like yours to undertake internal investigations. And I've gone in after there's been an internal investigation that's not external like I was. And I've identified that, in fact, that it was a very transparent, it was a very objective, independent approach, but that wasn't shared with the people involved, and as a consequence, I needed to get involved. So there's a lot to be said for sharing the reasons for the outcome and what that outcome is, so there's an understanding by the parties involved that they might not be, someone's not going to be happy with the outcome, but they might be able to live with it. Make sure you manage the expectations of the complainant from the outset and ongoing. Typically, the complainants may not have been involved in a process like this and they don't really understand what they're in for. So from the outset, start to talk to them about, start to set boundaries and start to manage expectations by letting them know what the scope and the process and the methodology will be, identifying to them that the evidence will be what informs the findings of fact and the outcome. Talk about the principles of confidentiality balanced against transparency. That's a tricky balance to manage. And talk about what the potential outcomes are. Explain to a complainant that the evidence may establish your complaint's made out, and that'll be sustained and we'll be taking action, and that might include a variety of things, both organisationally and in respect of individuals. But the evidence could potentially not be able to satisfy us that your complaint is not being made out. That doesn't mean we don't believe you, it just means that we can't be satisfied on the evidence that the complaint's made out. So from the outset, start to set those barriers so there are no surprises at the end of the process. This is probably one of the major failings and one that we really need to be addressing, and it's the key takeaway for you. I think, and that's investigating through the work health and safety risk management lens. So apart from looking at the events that comprise the complaint, you're also looking about how did we as a business manage this risk? Did we adopt the requisite risk management approach? So you're now benchmarking yourself like you would if there's been a strata-related incident or a gas-related incident. You're benchmarking yourself against the standards and the codes and the other authoritative material. You're doing that in this regard against the ISO standard and the code of practice, and you're saying, have we put the requisite controls in place? So, you know, have we identified, assessed, have we controlled so far as reasonably practicable? Have our staff been trained and instructed? Why didn't they intervene at an early point in time? Why wasn't this matter reported to us by the complainant until a late point in time when, you know, almost the horse has bolted, we could have intervened earlier? Asking all those questions beyond looking just towards the events that give rise to the complaint. And another failing is these allowing really generalised and vague complaints to go unchecked. So I was intimidated, I'm treated unfairly, and so on. You've really got to put it on the complainant to understand in detail what the complaint is. Don't accept generalised and very vague and broad complaints because you can't investigate them. You need to understand the detail. So get them to particularise the discrete events chronologically. Get them to put together in advance of you sitting down to speak to them a chronology of events. Get them to identify and or provide evidence and also witnesses. Who was present? Who was nearby? This incident occurred where? In the meal room. Who else was in the meal room at the time? You're looking for other evidence to support or otherwise the complaints that are being made to you. Try and keep conversations in first person and avoiding opinions and conclusions. The alternative to that is, however, if someone wants to draw an opinion or conclusion, let them do that. You know, I felt threatened, I felt intimidated, I felt belittled. Okay, what do you mean by that? Okay, that's the next question. When you say you felt belittled or when you say you felt intimidated, can you explain what made you feel like that and why and what it was that you perceived that caused you to feel that way? You're now starting to get down to factual related matters. Get them to explain if they can, if there's some links between the events that they're talking about. So you're starting to hear about all these different events. It would be probably lost on you if at all there's any connection. Ask the question, what do you say the connection might be? And then if the complainant wants to tell you, well, I think the connection might be this, that's something that you can take on board and you can start to explore yourself and try to understand whether there is any connection between the events that might help you understand the factual matrix and lead you to make some findings about them. Also, challenge complainants. This is a deficiency I see in a lot of investigations, even some of my guys. A complainant is always going to repeat their complaint over and over if you ask them to do that. But challenge them about that complaint. You know, if there's an alternative version, put that to them. What do you say about this? You know, but make sure you manage that, because if you start to give them counter versions and start to challenge their complaint, then what they can do is perceive that you're being unobjective when that's not the case. You're just challenging them. So the way you should manage that is at the outset of speaking to someone or interviewing someone, put them on notice that, look, I might challenge you about your complaint. I might put different versions that I understand or I have an understanding of to you. I don't want you to think that that means I don't believe you. That's not the case. It's just that it's incumbent upon me to understand your complaint and put counterversions and hear what you have to say about it. So that's a good way to try and manage that process, because if you don't and you just start to challenge and you just start to put counterversions, the perception can be, wrongly, that you've adopted a view or you're being unobjective. Generalised or vague surface level investigations. So that's another issue. And this, look, these sorts of deficiencies are more prevalent, I think, with harmful related behaviours, but these are sort of things that you can apply more broadly across your business in terms of deficiencies. So we need to be making sure we interview all witnesses and explore all lines of inquiry. So when we get an internal investigation and we might do a desktop review, one of the things that makes us draw the conclusion it's an inadequate investigation is all these complaints were made by the complainant and they've actually all been addressed. And also a number of witnesses have been identified by the complainant, and we see that there's statements taken from those witnesses. We're dealing with a company at the moment where we probably wouldn't be involved because we looked at the desktop review. We did a desktop review. It was an investigation undertaken by lawyers. It looked reasonable. It appeared to be detailed. It had some adverse findings which gave it some credibility. There were some outcomes. However, there were 8 witnesses that were identified by the complainant that weren't spoken to. This is not a detailed and in-depth investigation. If a complainant is raising you need to speak to these people, you need to go about that. And as a consequence in this case, we're now involved because those 8 people weren't spoken to and the investigation was inadequate. Background and context to a complaint is really essential. A lot of harmful behaviours and workplace interactions have a deeper background and context. So what's changed? If workers have been working together for a period of time and only now something's occurred, what's the background? What's the relationship? Has there been some change management in the workplace that's been poorly executed? Has there been some performance-related issues? Has there been other changes in the workplace that may be giving rise to an ulterior motive for this complaint? What is the background and what is the context that I've got to understand? And of course, don't want to labour the point, but again, we've got to be directing our investigation through a lens of work health and safety risk management. It's a really easy out to accept there's conflicting evidence. So you don't want to do that. At the end of the day, you might not be able to make a particular finding one way or the other. But when you're looking into events, don't just take the easy road out and say, well, look, there's conflict and we can't make a decision. Try to resolve that as best you can. You may not, but try to resolve it. Look at the timeliness of the complaint. Look at whether the worker or the complainant raised the matters in a timely manner with other people. Was there attendance in a timely manner upon a medical practitioner? But if there wasn't, that doesn't mean there's no merit to the complaint. You need to then ask the question, well, why was it that you didn't report it to us earlier? We've spoken to some of your colleagues and you haven't raised it. Why was that? There might be a very satisfactorily, late complaint may be satisfactorily explained, but you need to try and explore that. Witnesses without an axe to grind or no skin in the game are gold. So you can place a significant amount of weight on, it might be a witness that's been identified by the complainant as someone that could corroborate their complaint, and they do so. all of a sudden you've now got some corroboration by someone who hasn't got any skin in the game or any axe to grind. On the other hand, you might also ask that very same person the same questions, and they might say, well, I was there and it just didn't happen. So you can place a great deal of weight on people who don't have anything to fear as a consequence of the statements that they're making to you. I won't go through. I'm conscious of the bell, and I won't go through all of those dot points. I think they're all pretty self-explanatory. But before I leave you, talk about just a couple of easy ways to maybe improve your investigations of psychosocial hazards generally, and that is to consider addressing some of the matters that I've spoken about, that is the deficiencies and also the safeguards in your risk management procedures, in your investigations procedures, in your guidance material, in your training, and even in your templates, your investigation report templates that you might be providing to be prompts for where the investigation should ultimately end up and what should be in that report. So thanks very much for the opportunity to have a chat to you today about investigating these matters. They are a safety risk. We have to treat them like every other safety risk that we have in our business, and we have to treat them in a manner that looks at them through a work health and safety risk management lens. Thanks.